Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 of Jefferson County, Texas. This morning, we have our arraignment docket. And what the arraignment is, it basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. County Court at Law Number 2, Jefferson County, Texas, handle misdemeanor cases. Criminal cases are divided into felony cases or misdemeanor cases. He can sit up here on the that front row with that tag. We need to give him a tray too. And as I was saying, County Court at Law Number 2, we handle misdemeanor cases. So the case that you have is a misdemeanor case. Cases are divided into misdemeanor and felony cases. Your felony cases are more commonly referred to as your more serious type criminal cases. Misdemeanor cases are referred to as your petty offenses. It does not mean that they're not serious. It's just that the difference between the felony case and the misdemeanor case is the range of punishment. For your felony cases, you have a capital murder. You can get life or death. That's the punishment. For a first-degree felony, which is right below a capital murder case, the range of punishment is 5 to 99 years to life, or a fine up to $10,000. For a second-degree felony, the range of punishment is anywhere from 2 years to 20 years in the penitentiary, fine up to $10,000. And for a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. Now, the lowest felony that you have in Texas is what we call our state jail felony. State jail felony cases, the range of punishment is anywhere from 6 months to 2 years in the state jail, fine up to $10,000. Now, we handle misdemeanor cases. Your misdemeanor cases are divided into 3 classes. You have Class A, Class B, and Class C. Your Class C misdemeanors are normally, they're the cases that's handled in city court, or the cases that are handled in the JP, or the Justice of the Peace Court. For the Class C misdemeanors, you cannot be punished with jail time. You can be punished, however, with fine only. It's a fine only offense. Now, County Court at Law Number 2, we handle Class A and B misdemeanors. We only handle C misdemeanors if they get appealed from the JP court or the city court. Now, for the Class A misdemeanor, which is your highest misdemeanor, the range of punishment is confinement in the county jail for up to 1 year, a fine up to $4,000, or you can be given both such fine and confinement. For a Class B misdemeanor, the range of punishment is confinement in the county jail for up to 180 days, which is 6 months, a fine up to $2,000, or you can be given both such fine and confinement. Now, the forms that's been handed out, it states that as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If your choice is, or if you have already hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you've already been appointed a court-appointed counsel in your case, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive, which means I want to waive my right to an attorney and represent myself, waiving your right to an attorney is saying that you're giving up your right to an attorney and you're representing yourself. If you want to do that, then you'll put your initials on the fourth line, on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign where it says defendant, and you will put today's date, June 15th of 2021. Now, for those of you who have elected to waive your right to an attorney to represent yourself, you would have to read and sign the second page that's on the clipboard. And the second page on the clipboard is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is free, voluntarily and intelligently made. Furthermore, I have been advised this 15th day of June of 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that's your choice, then you will sign the second page where it says defendant, and then you will date it today's date, June 15th of 2021. Now, as a defendant in a criminal case, you have other rights as well. You have a right to have a trial by jury. And where a young lady is sitting, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case, and they'll decide whether or not you're guilty or innocent after listening to all of the evidence. Now, you have a right to waive your right to have a trial by jury, which means to give up your right to have a trial by jury and just simply have your case come before the court or before the judge. You can come before the judge through a trial. We call that trial a bench trial, or you can come before the judge on what we call a plea. A plea is where you're entering a plea of either guilty or no contest to your charges. Now, guilty, when you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. When you enter a plea of no contest, you're telling the court that you did not, you're telling the court that you will not be fighting or contesting the charges against you, or you can enter a plea of not guilty. And when you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Now, as I said earlier, you have a right to have a trial by jury, or you can waive your right to have a trial by jury and you just have your case come before the court, either through a trial or a plea. Now, you also have a right to have witnesses to come to court. That chair that's turned, we call that the witness stand. witnesses. They can testify for you, against you. You can ask them questions. We call that either direct examination or cross-examination. Now, you can waive your right to have witnesses to come to court as well, which means you can give up your right to have witnesses to come to court. And basically what that means is if you waive your right to have witnesses to come to court, you will not be calling any witnesses on your behalf in your case. The state will have witnesses in their case. Now, you also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. You know, if they may have documents, they may have videos, witness statements, your statement, etc. And so you have a right to have access to those documents through discovery. If you're represented by an attorney, your attorney will have access to it, to the evidence, or if you're representing yourself, you'll have access to the evidence. Now, you also have a right to waive or give up your right to have discovery. Waiving your right to have discovery means that you're telling the court that you do not request the discovery of the evidence in your case. You also, as a defendant in a criminal case, if you are represented by an attorney, as I said earlier, your attorney will have access to the discovery, or if you're representing yourself, you can have access to the discovery. You'll also have an opportunity to talk to the prosecutor. If your attorney is representing you, your attorney can talk to the prosecutor. The prosecutor is they work for the state. It's the assistant district attorney, okay? And if you're representing yourself, you'll have an opportunity to talk to the prosecutor or the assistant district attorney. And what you'll be talking to them about, Peppo, somebody just came in. Okay, now, as I was saying that you'll have an opportunity if you're representing yourself, or if you have an attorney, your attorney will have an opportunity to talk to the prosecutor or the assistant district attorney. And they will see whether or not they can work out a plea bargain agreement or a settlement on your case. When we say a plea bargain agreement, that's a settlement to see whether or not you can settle your case. Now, if, first of all, you do not have to work out a settlement if you do not desire to work out a settlement. But if you desire to work out one, and if you are able to work out a settlement agreement, I do not have to follow that settlement agreement. And if I don't follow that settlement agreement, you will be entitled to withdraw or take back your plea. Hold on a minute. And Angie, we'll be with you in a moment.
Yes, sir. Thank you.
No, I haven't.
Call Langston and let him know that his client is on Zoom. Okay, and as I said earlier, if I do not follow your settlement agreement, you'll be entitled to withdraw, which means to take back your plea bargain agreement. Now, if I do follow the agreement, and if you decide, they just went off. If you do follow the settlement agreement, well, if I do follow the settlement agreement, and if you decide that you would like to withdraw, which means to take back your plea, you have to get my or the court's or the judge's permission to take back your plea if we follow the settlement agreement. That's what the law says. Okay, now, if you get permission to appeal your case, then your case will go up to the Ninth Court of Appeals, which is on the 3rd floor of the courthouse. They will review your case. They can decide either to grant or deny your appeal. And what an appeal is, you're asking the court to look at your case to see whether or not you was wrongfully convicted, whether or not we committed an error of convicting you. That's the purpose of it. And so they'll review your case. If they grant your appeal, they can just simply find you not guilty. Or they could send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. That higher court is called the Texas Court of Criminal Appeals. They're located in Austin, Texas, and it is the highest criminal court in the state of Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you'll be representing yourself. Petition for discretionary review, you'll be asking them to review your case, to see whether or not your appeal should have been granted, see if you've been wrongfully convicted, to see if we committed an error by convicting you. If they grant, they can grant or deny your appeal, your pro se petition. Now, if they grant your pro se petition, they can just simply find you not guilty, case over. Or they can send the case back down to this court, order this court to give you a whole new trial. Now, if they deny your pro se petition, then at that point, your conviction will stand. Jefferson County District Attorney's Office has a program that is called pretrial diversion. It is a program where they dismiss the case and you could get it expunged from your record. Expunged means wiped off, deleted, or erased from your record. Like they check your criminal record date, it's not there because it was expunged. Now, in order to get into the program, you have to qualify. You have to get an attorney to help you fill out an application or to submit the application to the district attorney's office. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And the third thing is, it has to be your first offense. You can't have a long criminal history, okay? If it's your first time. Okay. So if,
can you hear, Judge?
yeah, I can hear. That's good. So if it's your first time getting in trouble, then you may qualify. So if you have a criminal history, the district attorney's office, you may not qualify. Okay. So as I said, if you get into the pretrial diversion program, case dismissed, you complete the program, you can get it expunged from your record. You would have to get with an attorney or someone to help you get an expunction. Okay. Langston buzzed in and buzzed out. Could you turn on? No, I get it. No, trying to tap it on. Langston.
Yes, sir.
Okay, we getting. I'm in the middle of doing an arraignment. Just give me a few minutes, and we'll be able to do your plea.
Okay.
All right. Okay, and so, as I was saying, for the pretrial diversion program, if you're in the program, you can get it expunged from your record. Now, if you are a veteran of any one of the branches of the United States military, they have a program. The district attorney's office has a program that is called Veterans Court. Only thing you have to do is be a veteran of any one of the branches. And what happened, as part of the pretrial diversion program as well, the state will, you complete the program, and once you complete the program, the case is dismissed, you can get it expunged from your record. Now, this court has a program that is called the CSI program, stands for Community Safety Initiatives, program that I started back in March of 2017. We've been doing it for over 4 years. That program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. And the program is designed to address what we call recidivism, people committing crimes over and over. And the way the program actually works is it's part of our bonding situation, or our pre-trial bonding program. And basically the way it works is we have a partnership with Spindletop, MHMR. Spindletop, MHMR, they have a program that addresses mental health needs, as well as they have an ATAR program that stands for Addiction Treatment and Recovery that addresses drugs and alcohol issues. Now, we also have, we work with Ozar, who can do a screening as well. Now, with the mental health side, they can do private interviews, they can do assessments, and they can develop treatment plans, either outpatient or inpatient treatment. On the drug and alcohol side, Spindletop or Ozar can provide interview screenings. They can develop a treatment plan as well that, okay, yeah, just hold on a minute. Angie.
Yes, sir.
Okay, we're gonna go ahead on and get him done. Okay,
Yes, sir. Yes,
okay.
sir.
All right, just put him back in.
Okay. What he is. Okay, you have a seat there, and your attorney Langston will pop up on the screen here shortly, okay? All right, just speak up so they can hear you though, okay?
I don't see, where is his stuff is from yesterday? Okay. Oh, here it is. We have a process, okay, 40 days. Hold on a second. I have to go to yesterday. Give me a copy of his PC and his information, because I don't. Mr. Adams, are you ready?
Yes, I'm ready. I'm ready.
Okay. Just give me the information right quick first. All right, we're on the record in cause number 328208 and cause number 328210. Both cases are styled the state of Texas versus Jimmy R. Thomas. We have Mr. Thomas appearing via Zoom. Mr. Thomas, can you hear me?
Yes, sir.
Okay, Mr. Thomas, would you please raise your right hand? Mr. Thomas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Sir.
Okay, you may put your hand down. Mr. Thomas, how are you doing?
Everything looks all right.
You doing all right? All right. Now, Mr. Thomas, you're here represented by your attorney, Mr. Langston Adams. Mr. Adams, how are you doing?
Doing well.
That's good. Now, Mr. Thomas, the information in this case in cause number 328208 alleges that on or about September 5th of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, this information further alleges that prior to the commission of this offense, that on November 4th of 1993, in the county court at law number 3 of Jefferson County, Texas, in cause number 172747, that you were convicted of the misdemeanor offense of driving while intoxicated before this conviction became final prior to the commission of this offense. Now, Mr. Thomas, do you understand what you've been charged with?
Yes.
And to this, now, Mr. Thomas, to the paragraph that alleges that you had a prior DWI conviction in 1993, is that true or not true?
No content.
No, I'm asking you about the paragraph that says that you were,
Not true.
that you were convicted in 1993. Is that true?
No. No content.
I understand. I know you plead no contest to the charge, but I'm asking you about the paragraph that says in 1993 that you had a prior conviction for driving while intoxicated. Is that true?
No.
It's true?
No. I have no video.
No, I'm saying, Mr. Thomas, listen to my question. The paragraph says in 1993 that you were convicted in County Court at Law number 3 for DWI in 1993. Is that true or not true?
Not true.
Okay. Mr. Adams, do you need some time to talk to your client?
I think, Judge, he's not understanding your question. But even with him saying no contest to that, I mean, he's not contesting that it's true. I believe that's what he's trying to say when he's saying no contest. He's saying that he's not contesting that it's true.
Yeah, but I'm saying, but since it's an enhancement paragraph, I have to ask him whether or not the enhancement paragraph is true before we get to the initial offense.
Okay, Mr. Thomas, can you hear me?
Yes.
What the judge is saying is that in the past, just think of word past, you were convicted, right? In the past, you got me?
Oh, the past.
Yes, right?
Yes.
Yes, that he understands. See, you got to break it down for him like that, Judge. So that's the answer to your question. Yes, he's saying that it's true. That's the past. I broke it down where he can get it.
Okay. Now, Mr. Thomas, now to the charge of DWI second, how do you plead? Guilty, not guilty, or no contest?
No content.
Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Excuse me?
You pleaded no
He
contest?
said yes.
Oh, I thought he said, excuse me. Oh. All right, now, Mr. Thomas, I also have before me a document that is on our computer tablet. And I think your attorney, Mr. Adams, on yesterday may have went over this with you. On this document, on page 2, there are a set of initials on a line that's titled Nola Contingere, which means no contest. And these initials are J, R, or T. Did you place your initials on this document?
Yes, sir.
Okay. And on the third page of the same document, there's a signature above the line that's titled Defendant. That signature is Jimmy R. Thomas. Did you sign this document?
Yes.
And on the next document, which is a trial court certification of defendant's right of appeal, there's a signature above the line, and that signature is Jimmy R. Thomas. Did you place your signature on this document?
Yes, sir.
And there are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
And the second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes.
Okay. Now, Mr. Adams, and the discovery certification, Mr. Thomas, did your attorney have you to sign a document that is titled the discovery certification on yesterday?
I think so. I can't see the good. I'm got a lot of comments.
I didn't understand it, Mr.
Yes, he signed the discovery certification.
Okay, now, Mr. Thomas, before you sign and initial these documents, Did your attorney, Mr. Adams, go over these documents with you? I couldn't understand it. Mr. Thomas, did your attorney? Oh, you say yes? All right. Now, did you have an opportunity to read and understand everything in these documents?
I don't have my glasses, I'm waiting for the company to read it.
I'm saying on yesterday when your attorney was there with you, did he explain everything to you in these documents?
Yes,
And did you understand everything that he explained?
yes,
And is everything in these documents true and correct to the best of your knowledge?
best of my knowledge, yes.
Okay. State, I have before me state's exhibit number 1. State, you also like to offer state's exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Mr. Adams, do you have any objections?
None.
Okay, no objections. State's exhibits number 1 and number 2 will be admitted. Mr. Adams, you've advised and counseled Mr. Thomas. Is there any evidence that he is currently mentally incompetent to stand trial?
None. I don't have any.
And Mr. Thomas, your attorney,
Yes.
Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Yes,
Has he provided full, effective, and competent legal representation? Mr.
Sir?
Thomas, has he provided competent representation?
yes, yes,
Okay. Okay, Mr. Thomas, I will accept your plea of no contest. I will find that you're mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. State, do we have a plea bargain agreement?
Yes, Your Honor.
And
It's for
what is that agreement?
40 days credit for time served, tax and retire court costs, and the state is dismissing cause number 328210.
Okay, Mr. Thomas, the state is offering that you serve 40 days in the Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you've already served 40 days. Therefore, you'll be given credit for time served. If you owe any court costs, you will not have to pay the court costs either because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. And the state will be dismissing cause number 328210. Mr. Thomas, do you understand the state's offer?
yes,
And do you think that the state's offer in your case is fair and just?
yes,
And do you accept the state's offer?
yes.
Okay,
Yes.
Mr. Thomas, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Thomas, this will conclude your cases. Please follow the
Okay.
bailiff, and you have a blessed day.
All right, you guys have a wonderful day too.
Okay, and
right.
Angie,
Yes, sir.
thank you. Thank you very much.
You're welcome, Judge. Thank you.
Okay.
All right. Bye-bye.
Your Honor, I'm going to get off of Zoom and come downstairs.
That's fine.
I'm gonna leave now, Judge.
Okay,
Give me a day. Hello?
okay. Mr. Adams, this will conclude your case, and you have a blessed day as well. Okay. Okay, ladies and gentlemen, that was a little unusual. We don't usually have a plea in the middle of a middle of our arraignment. But I think as I was saying, I was telling you about I told you about the pretrial diversion program. I told you about the Veterans Court, and I was telling you about the program that we have here, which is part of our CSI program. We call it the Community Safety Initiative. We have a program, partnerships with Spindletop. We have some individuals who are in court from Spindletop who could do a private interview. They can do Spindletop can do an assessment and a treatment plan as well. And then if anybody have issues with drugs or alcohol, partnership with Spindletop as well as Ozar, we can refer them to Ozar to do a interview, a screening, and they could develop a treatment plan, either outpatient or inpatient. Now, for individuals who are unemployed, need work. We have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program. You train in the hotel industry or the shipping industry or the chemical industry. And once you are trained in one of those areas, they will assist you at getting a job in the area that you're trained in. And if anyone have not finished high school and you would like to get your GED, Lamar University CICE has a program for a GED where you can get your high school equivalent diploma. Now, all of these programs that I just spoke of are free. It doesn't cost you anything. The only thing you have to do is have a desire to be in the program. The other thing is all of these programs can be used as community service in your case. Now, if everyone in here has that's here for arraignment, you have been arrested, you're out on bond, and every day that you spent in jail, you can get credit on that toward your punishment. So for example, if the state is offering you 5 days in the Jefferson County Jail, you've already spent 5 days in the Jefferson County Jail, then you can get credit for time served. Every day that you spent in jail, you get credit at $100 per day toward your fine and court costs. So if the state is offering a fine and court cost of $500, you already spent 5 days in jail. That's $500. Your fine and court costs could be taxed and retired, which means you won't have to pay a fine and court cost because the time you spent in jail has already paid it off. And if you have, if you've been ordered to pay a fine and cost and you can't pay it on the day of the plea, we can give you time to pay it off, or we can put you on a payment plan where you pay so much per month. But let's say, even if we put you on a payment plan, you can't pay it off. Then what we can do is convert your fine and court costs, to community service. You get every hour of community service that you do, you will get $12.50 that will go toward your fine and court costs. So if you work an 8-hour day, community service, that's $100 that goes toward your fine and court costs. Okay. Now, all of the programs that I just mentioned to you earlier, if you're being trained, let's say you're in the CICE program, you're being trained for something. Every hour that you spend in that class, every hour will go toward your community service, and $12.50 can go toward your fine and court costs. So you're doing one thing, but you're getting credit for three things. The program is one thing, the community service is another thing, the fine and the court cost is the third thing. So I tell people this all the time, you're killing 3 birds with 1 stone. And so all of these programs are free. And I tell people this all the time, when you come to county court at law number 2, we don't have court as usual, we have unusual court. And the reason why I say that is not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court. And we're trying to make a difference in Jefferson County. And so we're trying to produce productive people, because if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so with that being said, we have someone here from Spindletop, Deputy Hinton, our mental health officer. He's going to come and tell you a little bit about the program that they have with Spindletop. Deputy Hinton.
Thank you, Your Honor. Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. I'm here with my partner, Mrs. Shelby. She is a qualified mental health professional with Spindletop. The reason we're here is because the judge has graciously allowed us in his courtroom because he does care about people. So we're here, and what we found was that people who have legal issues commonly cycle in and out of the courtroom, in and out of the jails, because there's underlying issues such as mental or substance use disorders. So we feel that we can address those and help you with those, and we can eliminate a lot of your cycle of arrest. That's our goal, that's our objective. It's going to take one thing, and it's going to be for y'all to tell us. We don't know if we don't ask, and that's what we're doing this morning. And we don't know if you don't tell us. So we'd like you to share that with us privately. We want to respect your privacy and your information. We can also meet with you in the back of the jury panel room and visit with you and give you more resources, more direction, but we like to help you if you'll give us that opportunity. But it's gonna be up to you. But
You
as
got
the
that
court
paperwork?
proceeding continues, I'll be speaking with every one of you and talking to you, giving you that option. We also have a brochure that tells a little bit about exactly what we do here. Should you have family members or something, you want to take this home and maybe share it with them, we'll be glad to help them as well. There's a phone number on the front here. We're not going to be able to get to everyone that wants to speak. We understand that. We want to respect your time as well. So we want to make sure you have something to take with you as well, so we can help you when you leave here, if this is something that you want to take advantage of. Does anyone have any questions? Thank you. You're very kind.
Okay, ladies and gentlemen, just my final statement that I will make before we have some folks from the staff. They're going to take the information from you, and then we're going to put you in various 3 groups, and we're going to try to make this as smooth and as fast as possible. And the last statement I like to say here with our program in County Court at Law number 2, we do not just arrest the problem, we address the problem. And so we feel as addressing the mental health issues, drug and alcohol issues, unemployment, lack of education, then because all of those issues cause people to commit crimes. And so that's why we are trying to address the issues instead of just arresting the issues. So at this time, our staff will just be a little patient with us. We may have you to step out of the courtroom because we have a, well, if you want to stay in, you can as well. We're gonna have we got a hearing going on. So ladies and gentlemen, this is an arraignment, but for the day, you're probably seeing a lot of stuff that we do in county court. You've seen a plea, now you may sit in and see a hearing. So just be a little patient with us. We're gonna try to get through this as fast as possible. Thank you for your time.